The court just changed everything. If you own a gun in America, if you carry, if you train, if you believe the Constitution still means what it says, then what just happened in federal court this November affects you directly. A federal appeals court just dropped a legal bombshell, one that rewrites how gun laws work in all 50 states. This ruling doesn't just tweak the edges of the law, it redefines the rules of engagement for every gun owner in the country. 10 major changes, 10 legal earthquakes that could change how you buy, carry, and defend yourself with a firearm. So hit that subscribe button, stay alert, and let's break this down, one rule at a time. Because what you don't know about these new rules could cost you your rights or your freedom. Weapons Law Advisor is here to make sure that never happens. Chapter 1. Strict scrutiny becomes the mandatory standard. This first change is the foundation, the one that makes everything else possible. For decades, courts allowed the government to pass gun restrictions without truly proving they were necessary. But that era is over. The November ruling confirms that every single gun law in this country must now survive strict scrutiny, the highest constitutional test that exists. From now on, if the government wants to limit your gun rights, it must prove 3 things. There's a truly compelling reason, not just a good idea. The law is narrowly tailored, not overreaching. There's no less restrictive alternative available. That flips the burden of proof completely. The government now carries the full weight. Thousands of state and federal gun laws across America just got pushed onto shaky ground. And the ripple effect is massive, especially when it comes to your personal defense and your wallet. Chapter 2. Civil Liability Shield for Lawful Defense. This one could save you from financial ruin. For years, even if you used your gun legally in self-defense, you could still be destroyed in civil court. A man in Ohio shot a burglar breaking into his home at 2 a.m. No criminal charges filed, yet the burglar's family sued him for $400,000. A woman in California defended herself from an attacker. The attacker's family sued her for over $1 million. Those days are over. The court's ruling creates absolute immunity from civil lawsuits when your use of force is lawful self-defense. The criminal, or their family, cannot sue you for their injuries. And here's the key. A civil case can't even begin unless prosecutors first prove your actions were criminal. The burden now falls entirely on anyone who tries to come after you. If you acted lawfully, you're shielded. Your defense ends when the threat ends. Chapter 3. Law Enforcement Accountability Standard. For the first time, police officers who violate your Second Amendment rights can face personal consequences. For decades, qualified immunity protected officers from liability, even when they unlawfully confiscated firearms or violated carry laws. That protection is over. Under this ruling, officers can be sued personally if they infringe on your clearly established gun rights. In Virginia, one officer recently confiscated a legally carried handgun during a routine stop, despite a valid permit. He just lost a $300,000 personal judgment. This new accountability standard means no more hiding behind a badge when the Constitution is being violated. If your firearm is taken without cause, you now have legal ground to fight back. Chapter 4. Sensitive Place. Restrictions narrowed. For years, states like New York, New Jersey, and California found clever ways to ban carry almost everywhere. They couldn't outlaw guns outright, so they declared nearly every public location a sensitive place. Parks, theaters, public sidewalks, even parking lots, all off limits. Not anymore. The new ruling slams the door on that tactic. The court established a strict 2-part test for what truly qualifies as a sensitive place. A courthouse with metal detectors and armed security, valid. A school with police protection, valid. But a public park with a no gun sign, not valid. Private businesses can still ask you to leave, but they can't have you arrested just for carrying lawfully. States are now being forced to cut their sensitive place lists by up to 80%. The message is simple. Your rights don't disappear when you walk into a public space. Chapter 5. Carry Permit Processing Timeline. For years, bureaucrats weaponized time itself. States like New York, Maryland, and and Hawaii sat on permit applications for months, even years, knowing most people would give up. That's over. Every state must now approve or deny your carry permit within 60 days of receiving your application. If they don't, your permit is automatically approved by default. States can't stall. They can't request endless additional documents. And if they deny you, they must issue a written explanation citing specific legal grounds. In just 3 weeks since the ruling, some states have processed more permits than they did in the previous 6 months. The clock is ticking, but this time it's ticking for freedom. Chapter 6. Ammunition Storage Mandates Struck Down. This one hits close to home, literally. For years, states tried to make your gun useless by separating it from your ammunition. Massachusetts required ammo to be locked away separately. California said ammo had to be stored in another room. Some Illinois counties went even further, different floors. In a real emergency, that's not safety, that's suicide. The court ruled that any law preventing immediate access to ammunition violates the Second Amendment. You have the right to store your firearms and ammunition however you see fit, together, ready, and accessible. The government has no authority to dictate how you secure your home for defense. Chapter 7. Firearm Registry Prohibition Reinforced. Federal law has banned a national gun registry since 1986, but states have quietly built their own databases anyway. California's dealer record of sale system held over 20 million firearm records linked to specific owners. This ruling just blew that system wide open. The court ordered that any state-level registry tracking specific firearms or owners is unconstitutional and must be destroyed within 180 days. States must issue written proof to gun owners confirming deletion of their data. Failure to comply, contempt charges, and daily fines. The court made it clear tracking the innocent is not public safety. Chapter 8. Federal Firearms License Reform. For years, the ATF used Federal Firearms License, FFL, rules as a weapon, shutting down dealers over minor clerical errors. Write the wrong date, lose your license. Use blue ink instead of black, lose your business. That ends now. The decision states clearly, the ATF may only revoke an FFL for actual criminal violations, not paperwork mistakes. They must issue a written warning and allow time for correction before taking action. This change protects small gun dealers and stops bureaucrats from using red tape as backdoor gun control. The rules of engagement have changed permanently. Chapter 9. Concealed Carry Reciprocity Expansion. Crossing state lines with your firearm used to be a legal minefield. A valid Georgia permit meant nothing in Florida. Gun owners had to memorize maps and pray they didn't cross the wrong border. Not anymore. The new ruling establishes a national baseline of reciprocity. If you hold a valid concealed carry permit in your home state, at least 42 other states must now honor it. Your Texas permit works in New Mexico. Your Florida permit works in Georgia. States can't create extra hurdles for out-of-state carriers. If it's valid where you live, it's valid across most of America. Law enforcement is already being retrained. Your rights now travel with you. Chapter 10. Enhanced Castle Doctrine Protections. This is the one every homeowner needs to hear. In too many cases, law-abiding citizens defended themselves, only to face prosecution afterward. A Maryland woman shot an ex-boyfriend breaking into her home despite a restraining order. She was charged with attempted murder. A man in Texas stopped a violent burglar and spent 2 years in court proving his innocence. Not anymore. The November ruling shifts the burden of proof in home defense cases entirely onto prosecutors. If you use a firearm to protect yourself in your home, the state must now prove, beyond a reasonable doubt, that your actions were not justified. You're presumed to have acted in self-defense unless the evidence says otherwise. It's a massive restoration of the Castle Doctrine, and a victory for every homeowner who refuses to be a victim. Final chapter, the new era of gun rights. These 10 chapters mark one of the biggest shifts in gun rights in modern American history. They redefine how you buy, carry, and defend your firearms, and they reaffirm one simple truth. Rights don't wait for permission slips. Gun owners have played defense for decades. But after this ruling, the tide is turning. The burden is now on the government, not you. So stay alert, stay informed, and never get caught off guard. If this breakdown just saved you from a legal trap you didn't know existed, hit that subscribe button and ring the bell, because this fight isn't over. It's only just begun. And here at Weapons Law Advisor, we'll make sure you're always one step ahead.